Have you ever had one of those aha moments? You know, that brilliant, maybe even world-changing idea that just pops into your head and you think, wow, this could really be something. It's an amazing feeling, right? But that initial spark, well, that's just the start of the journey. A journey to protect your idea and, hopefully, turn it into something real. So, you've got this incredible idea. You're excited, you're buzzing, but then the big question hits you. What's next? I mean, how do you make sure your unique concept actually stays yours? How do you stop somebody else from just taking it and running with it? Well, the answer to all of that lies in the world of patents. So let's dive in and break it all down. All right, the very first stop on our inventor's journey is to understand the destination itself. We got to know exactly what we're aiming for. And that big prize, that legal shield for your invention, is called a patent. Okay, so let's really get into what a patent is, piece by piece. First off, it's a legal record. Think of it like an official, government-stamped certificate just for your idea. This record gives you an exclusive right. Now, this is the really important part. Exclusive means you and only you get to call the shots on what happens with your invention. But this power isn't unlimited. It's for a limited duration and in a limited geographical domain, which we'll get to in a sec. The whole point, though, is to give you the power to legally block anyone else from making, using, or selling your invention unless they have your permission. It's basically your own legal fortress. So what does limited duration actually mean? Well, in India, the magic number is 20 years. That's 2 full decades, and the clock starts ticking from the very day you file your application. For 20 years, that powerful exclusive right is all yours. This gives you a really significant head start to develop your idea, get it to market, and build a whole business around it before anyone else can jump in and compete. Now, before you even start dreaming about filling out forms, there's a huge choice every inventor has to make. It's like you're standing at a strategic crossroads. Do you go down the path of patenting your idea, or do you take a completely different route? Okay, so on one side, you can patent it. You get that 20-year monopoly we just talked about. You're in total control. But on the other side, you could choose to place your invention in the public domain. This means you publish it for the whole world to see, making it totally free for anyone to use, learn from, and even build upon. Now, you might be asking, why on earth would I just give my idea away? Well, imagine you invent a new, super efficient way to code something. By releasing it publicly, you stop any single company from owning it. This actually encourages other developers to use it, and your method could become the new industry standard. It's a strategic move. Do you want short-term control or long-term collaborative influence? All right, so let's say you've made your choice. You're on team protection. You want that patent. But it's not as simple as just having a cool idea. There are some very strict rules. 3 core conditions that your invention absolutely, positively has to meet to even be in the running. The first, and maybe the most black and white condition, is novelty. Your invention must be new. And new has a super strict legal definition. It means it cannot have been published or used anywhere in the world before you file your application. So if your idea is already out there, in a scientific paper, a blog post, a product for sale, even in a talk you gave at a conference, it's probably not considered novel anymore. It has to be a genuinely new thing. Next up is the inventive step. See, just being new isn't quite enough. Your invention also has to be non-obvious. The way they test this is to imagine a hypothetical expert in your field. The law calls this person skilled in the art. Now, if you showed this expert the problem you're trying to solve, would your solution be an obvious, logical next step for them? If the answer is yes, then it doesn't have that inventive step. Your invention has to be a real creative leap, a clever solution that wouldn't just pop into the head of anyone working in that area. And finally, the third condition is industrial applicability. Your invention can be brand new and totally non-obvious, but it also has to be useful. It has to be capable of being made or used in some kind of industry. This is what keeps the patent system grounded in reality. A purely theoretical idea with no practical application, no matter how brilliant it is, isn't going to cut it. Your invention needs to have a real, tangible purpose. It's also really important to know what you can't patent. Indian law specifically says no to certain things. For example, you can't patent frivolous ideas that go against the laws of physics, like a perpetual motion machine. You can't just discover a new scientific principle and patent it. Methods for treating patients are out, as are things like books, music, or art. That's what copyright is for. And very importantly, you can't patent traditional knowledge that's been around for generations. The system is here to protect inventions, not discoveries or art. So, your invention is novel, it's non-obvious, and it's useful. You've double-checked and it's not on the excluded list. Great. Now we start the actual trek, the formal step-by-step process of applying for and hopefully getting your patent. Okay, before we go a single step further, I need you to listen very, very carefully. This is the single most important rule in this entire game. Do not publicly disclose your invention, not until you have officially filed your patent application. That means no blog posts, no talks at conferences, no YouTube demos, nothing. Any public reveal before you file can instantly destroy your invention's novelty in the eyes of the law. And just like that, your chance of getting a patent is gone. Keep it secret, file first, always. Whew, okay. With that warning hopefully burned into our brains, here's the path forward. Step 1, search. You do a really deep dive to make sure your idea is actually new. Step 2, draft. You prepare the formal application. This can be a simple provisional version to just lock in your date, or the full detailed complete version. Step 3, file. You submit it all to the Indian Patent Office. Then you wait. After 18 months, your application gets published for the world to see. Then comes a key step you have to take. Step 5, the request for examination. This tells the Patent Office, hey, I'm serious, please look at my application. They'll then examine it, and if it checks all the boxes we talked about, you hit the final step, grant. Your patent is officially yours. Of course, this whole process isn't free, but take a close look at this fee structure. The Patent Office has 2 different price tiers, one for individuals and startups and another for bigger companies. And the difference is huge. Filing an application costs a startup 1,600 rupees, but it's 8,000 for a large corporation. The examination request is 4,000 versus 20,000. This isn't an accident. It's a deliberate government policy to make innovation accessible and to really encourage new inventors and small businesses. Okay, let's fast forward. You've navigated the whole process, you've paid the fees, and your patent has been granted. First of all, congratulations. But what does life as a patent holder actually look like? What new powers do you have? And more importantly, how do you use them? This quote right here gets straight to the point. The right you now have is monopolistic in nature. Wow, that's a strong phrase, isn't it? It means you now have the full legal power, as the owner, to stop anyone else from making, using, selling, or even importing your patented invention unless they get your permission first. You are in the driver's seat. So what happens if someone ignores your patent and uses your invention anyway? Well, that's called infringement, and it usually comes in 2 flavors. Direct infringement is the simple one. Someone is straight up making, using, or selling your invention without asking. It's a direct copy. Indirect infringement is a little trickier. This is when someone doesn't make the thing themselves, but they actively encourage or supply the parts for someone else to infringe on your patent. Think of them as an accomplice. But either way, your rights are being violated. But here's the good news. When infringement happens, you can fight back. As the patent owner, you can sue the infringer. The courts can give you a few different kinds of help. An interim injunction is an order to make them stop the infringing activity right away, while the case is still going on. You can also get damages, which is money to compensate you for the harm they've done. And finally, you can get a permanent injunction, which is a final court order telling them to stop for good. All right, let's wrap up our journey with the key things you need to remember. First, a patent gives you a powerful 20-year exclusive right. To get it, your invention has to pass 3 big tests. It must be novel, have an inventive step, and have industrial applicability. The road to getting that patent is a formal step-by-step process, and once you have it, you have the full power of the law on your side to stop anyone who tries to copy you. And that brings us to a final big thought. Patents are designed to spark innovation by rewarding inventors with a temporary monopoly. But sometimes, those very same exclusive rights can slow down wider progress. It really brings up a deep and important question for us all to think about. How do we find the right balance between rewarding the individual inventor and making sure that society as a whole gets to benefit from new technology? There's definitely no easy answer to that one.